Welcome to Immigration Answers with Seth.
Welcome to Immigration Answers with Seth, the immigration attorney Seth D. Stringer, founder of the Stringer Law Firm in Birmingham, Alabama. Seth helps immigrants in Birmingham, across Alabama, and beyond find safety and stability through VAWA petitions, U visas, family-based immigration, asylum, and naturalization. I'm Lisa Mosbey, your host, and today we're looking at two immigration paths that often come up in different situations, VAWA and U visas, and how they differ when it comes to eligibility, evidence, and long-term outcomes. Welcome, Seth. Thank you so much for joining me today.
Good to see you too.
Seth, if someone is trying to understand their options, what's the difference between a VAWA case and a U visa case?
Okay, so a VAWA case is an immigrant case. A U visa case is a non-immigrant case. So the VAWA is a direct path to a green card. However, a U visa is not. It will give you protection inside the United States from deportation, but it is not a direct path to a green card.
How can someone tell if their situation fits better under VAWA rather than under U visa?
Well, first of all, they need to talk to an attorney about that. But generally speaking, if you are married to a U.S. citizen or a lawful permanent resident and the crime is abuse against you by this U.S. citizen or lawful permanent resident, then you may qualify for the VAWA. Otherwise, you should probably look into a U visa designation.
And when a situation involves a crime or interaction with police, how does that connect to qualifying for a U visa?
Well, again, it would need to be under one of these categories for U visa designation. So if it's a felonious assault, then that qualifies. If it involves extortion, that qualifies. There's a list of unqualifying crimes. It's not exhaustive. It's not very lengthy either. But if you can fit into one of these categories, whether it's by a private individual or law enforcement, then you should be able to qualify. The problem with that is if it is law enforcement, then you may need to take some extra steps to get to another organization, law enforcement organization, who would sign off on you applying for this U visa designation.
Is it possible for someone to qualify for both VAWA and U visa? And how do you sort through that?
Well, yes. So, for example, a person may be married to an abusive U.S. citizen. So, if this person has been physically assaulted, that's domestic violence. So, technically speaking, they would qualify for a U visa application. But depending on the circumstances, they could also qualify for the VAWA application. One of the things for a VAWA application is that you must show that you have lived with the perpetrator. So if you're not able to show that you've lived with this perpetrator or that this perpetrator is a U.S. citizen, then you may want to think about going to the U visa route. However, generally speaking, we should be able to find sufficient evidence to show that you've lived with this perpetrator or that this perpetrator is a U.S. citizen or lawful permanent resident. Otherwise, then we would probably need to think about going to the U visa route.
So, when it comes to proof, how does the evidence differ between a VAWA case and a U visa case?
U visa case is fairly black and white. Are you the victim of a qualifying crime or not? Will law enforcement help you get this designation? Yes or no? VAWA is many shades of gray. It's the burden of proof is very, very personal, whereas the U visa is more objective. So for the VAWA, you would need to show that you've lived with this person. You would need to show that this person is either a U.S. citizen or lawful permanent resident, and you would need to show the abuse. So that is where the key lies, showing the abuse. So if you cannot show the abuse, then you're not going to get this VAWA designation. A lot of my clients are embarrassed by what they went through. They may be too prideful to explain in detail what happened to them. I try to explain to my clients, this is between you, me, and the government. Your spouse does not need to know. They will not know about this unless you tell them. They cannot find out any information about what's going on in this case through USCIS, through any other organization. Even I, as the attorney, cannot contact USCIS and try to find out the status of a case through VAWA because it is that tightly sealed. You, as a victim who filed this VAWA petition, cannot contact USCIS and find out what's going on with the case. It is that tightly sealed. So once a case is filed and accepted by USCIS, we may not know what's going on with the case until we get further correspondence from the government, which could take years.
Seth, can you walk us through an example where choosing between a VAWA and a U Visa made a real difference in how a case turned out?
Well, I've not had the experience where a client had to choose between the two. Generally speaking, the clients will want to go through the VAWA process because that is the quickest process to get a green card. The U visa, you have to get the U visa designation. That could take a couple of years, and then you'd have to wait for a visa to become available to you, at which point in time you would have that visa, and then you would have to wait a few years before you applied for the actual green card itself. And then you would have to wait for the processing for the green card in order to get your actual green card. Whereas in a VAWA case, you can apply for everything at once. Sometimes if a case is very weak, I suggest to my clients, let's go ahead and file the VAWA and wait to see what USCIS says. You'll still have some protections by filing the VAWA petition, and then assuming that everything goes well, assuming you do qualify for the VAWA petition, we can apply for the green card application then. And that, again, gives my client a little bit more protection from deportation. The reason I say that is because once we file the application for permanent residency, at the same time we file for the application petition for VAWA, if the VAWA is denied de facto, the application for permanent residency will be denied, and that could put you in danger of getting a notice to appear and sending you to immigration court.
So, while a case is pending, how does the experience compare between these two paths?
Okay, so for the VAWA, if we file the petition for the VAWA, application for permanent residency, and application for work authorization, we are waiting for all three at once. We're waiting for the USCIS to make a decision on the VAWA application, at which one time they will go to the adjustment of status application. However, since we did file the work authorization application, we would be waiting for the work authorization to come to my office or to the client's residence. At that point in time, they can start working legally and they can get other documentation that they need, such as a driver's license. However, for the U visa, you are not immediately authorized to work. You would have to wait a while, perhaps a couple of years, before the U visa is quote unquote approved, at which point in time, then you could get your work authorization. Because people are so anxious to get that work authorization, if it is possible, they will go with a VAWA application instead of the U visa application. However, a lot of the times they're only eligible for the U visa application because perhaps the abuser is not a U.S. citizen or lawful permanent resident, and they just have to wait their time in line before they can get their U visa approved and get their work authorization.
And then looking at long term, how do VAWA and U visas differ when it comes to things like work permits or getting a green card?
Okay, so again, the VAWA is a direct path to a green card. We apply for the VAWA at the same time we apply for the green card. So it's going to be processed at the same time. So once the VAWA is approved, generally speaking, the green card will be approved. You may need to go for an interview with USCIS to get your green card, but it is approved generally at the same time. However, with a U visa, you have to wait. You have to apply for the U visa, wait, then get your work authorization, wait for a green card to become available for you in your category, which again could take years for you to get. Then you can apply for your green card, and then 5 years later, you can apply for, once you get your green card, 5 years later, you can apply for your your citizenship. However, with a VAWA, if you're married to a U.S. citizen, you are still under that 3-year rule, meaning that you can apply for your citizenship 3 years after you get your green card.
Seth, for someone who's still unsure where they fit, what usually helps bring clarity to that decision?
Generally speaking, if you are married to an abusive U.S. citizen or lawful permanent resident, and your story is strong enough and we have enough evidence, I suggest we go with a VAWA. Again, that's going to make the client happy because they can get their work authorization more expeditiously. Otherwise, then we may just have to muddy through the wait line for a U visa.
That's it for today's episode of Immigration Answers with Seth. If you'd like to learn more about Seth and his work at the Stringer Law Firm, visit stringerimmigration.com. You'll find clear information about VAWA, U visas, family immigration, asylum, and other ways to protect your future in the United States. Thank you for listening, and don't forget to subscribe, share, and leave a review so more people can find the answers they need. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.